Yesterday we saw the first appearance of the grade 11 17-year-old at the Culloden Magistrates Court. Crowds gathered outside the court where this teenager appeared, charged with the murder of 16-year-old Deveney Nel. There had been some outside of court, as you heard there in Eyewitness News, calling for the 17-year-old to be tried as an adult. Court was held in camera because legally this suspect is still a legal minor being held at a place of safety. Karabo Ozah, director for the Center of Child Law. When we talk about the definitions of being of minor age, there is a difference when in how the courts decide. When it comes to the age of criminal capacity, the courts have made a provision for 3 different age groups. What are those different age groups, and how does this affect that 17-year-old charged with the murder of Deveney Nel? Karabo, good morning.
Good morning, Lester, and thank you for having me. I think as a starting point, we must not conflate the age of criminal responsibility and the age of being a child. So a person is a child until they're 18 years old. So I'll come back to that in relation to the court taking place in closed as a closed court under the Child Justice Act. When it comes to criminal capacity, we have, I would say, 3 categories. So a person under 12 cannot be charged because the law presumes they don't have criminal capacity. And then if you're between 12 and 14, there is a rebuttable presumption where the state can prove that you did have criminal capacity. Then when you're 14 and above, the law presumes that you have criminal capacity unless, for instance, it's proven that maybe you had a mental health issue or, you're not mentally sound, which requires you then to be assessed. So those are the issues pertaining to criminal capacity. Then if you are a child who commits an offense or is accused of an offense and you're above 14, obviously the law assumes you have criminal capacity, and then you're still under 18. So because you're still under 18, the Child Justice Act and the Criminal Procedure Act read together say that the proceedings must take place in closed court. Only people who are officials, only the accused family or guardians can be in the presence of the court, right? So that is the starting point. We don't have provisions for charging children as adults and all those things. And all these provisions are linked to what's in the Constitution. The starting point, as I say again, being that the Constitution says everybody is a child until they're 18. And then secondly, there's also Section 28(1) G that says that when you are dealing with children who've committed offenses, even if they end up being found guilty, there must only be a sentence for the shortest appropriate period of time. So there's a lot of legal provisions in relation to those protections. Obviously, people will say why, and I mean, we do understand you do find now and then children committing serious crimes, but the starting point is there that you are dealing with children that may have been influenced by adults, but if not, maybe the focus is maybe they can be rehabilitated, and the minute you expose them and expose their details, that diminishes the space for them to be rehabilitated.
And so at this time, the law still ensures the dignity and the protection of this minor child, even though he is charged with a serious offence. But I'd like your thoughts on many public interest groups, many residents of the Overberg. In Eyewitness News, we ran a clip of a community campaigner wanting this child tried as an adult. Your thoughts on the community's concerns and the community's wanting to see a serious action being taken in this regard, even though the suspect at this stage is still a legal minor in South Africa.
Yes, so as I said, legally there is no way. We're not like in the US where they have provisions for trying children as adults. And that comes from, as I say, the Constitution, but also the international law that we have domesticated. One can understand the seriousness of the offense, the fact that people are scared and are worried. Lisa, let me explain that, in the past, the Criminal Procedure Act was a bit unclear as well in relation to can you ever reveal the details of a person who was a child when they were accused of a crime and all those things. So we must remember that there are fair trial rights that apply, and they also apply to adults. We've seen many times they will say we can't reveal details of an adult until they've appeared for the first time. So equally for children, we can't reveal their details But in their case, because the law says you can't during the process at all, you cannot. You can publish what was said in court if the court allows you, but you cannot give identifying details in relation to that child accused. And then what we then have is that the Criminal Procedure Act, after we litigated, in the case of KL, who was Deveney Nel, the Constitutional Court gave an order that Section 153 and 154 of the Criminal Procedure Act must be amended to make it clear how you deal with the cases of child offenders and child victims. Now, what the law now currently has in relation to proceedings where you have a child accused who's under 18 is that Section 1543, which is a recent amendment to the Act, again confirms that you cannot reveal identity of that child who's an accused unless if there's a process where maybe they were not known or the police are trying to get hold of them, then you can publish that. After the conclusion of the trial, after, let's say, the 17-year-old is now found guilty, right? After that, if there is somebody who alleges that it's in the public interest for that person who was a child or who may still be a child at the conclusion of a trial, for their details to be published, there is a process where you have to make an application to court and explain why is it that is in the interest of justice for that person's details to be revealed. I think as much as there's community outrage, the question remains, well, he's already been arrested. What is the interest of the community in revealing his identity? It's not like somebody who's still out in the community who's actively posing a danger to other children and all such things. So it's quite a complicated process that we must understand and go with.
And this is only the first appearance. We don't know the basis of the state's case. The case could be withdrawn. The case could go on to trial. The case could go on to trial and only be concluded in many months, if not years' time. Would the legal protections continue even after the suspect is no longer a minor? I know you touched on it now, but say this case does go to trial. He is then convicted. He's now no longer a minor. Would those protections continue?
Yes, the starting point is that the protection continues. It would continue unless, as I said, unless somebody comes and applies that it's in the interest of justice. Even the prosecution could actually make an application to the court, and that's Section 154, capital letter 3B of the Criminal Procedure Act, which is a recent insertion into the Act that says that if the person has attained 18, there are processes that can be taken to then approach the court and say to the court, it's in the interest of justice for the court to reveal the details of that person, and the court will then hold a hearing about that and make a court order whether that person's details should be made public or not. For instance, if a child or a person who was a child then continues to commit crimes after they become an adult, or they pose a risk continuously to community, and it's in the interest of justice and the community for people to know who that person is, then there'll be grounds for the court to consider actually revealing the identifying details.
Karabo Ozah is Director for the Center for Child Law. Really appreciate your time. 021-446-0567. Your thoughts? I'm very much inclined to say that there are two children involved. Your one is 16, one is 17 years old. Of course, we do not dismiss the abhorrent nature in which Deveney Nel was killed, but I think we also need to protect the dignity and to legally protect the status of still a youngster, grade 11, and still only 17 years old. Still early days, only first appearance yesterday. This case could go anywhere from here.